popular magazines such as Forbes and newspapers such as the New York Times begin to discuss legal affairs, the contents of such discussions are no longer potentially explosive situations, they are situations which have arrived. So it is with the liability of governmental institutions. Two specific articles, which I have mentioned above, discuss the insurance implications in connection with liability actions, and we'll come back to that later. But first, I would like to discuss a few introductory comments defining the problem and laying the basis a little for my later case explanations. In order to understand what the problem is all about, two concepts should be kept in mind. The first is the concept of the sovereign. Our government is modeled on the English governmental form, with its basis in the common law. The history of common law is really one dealing with the struggle between a monarch possessing absolute power and his subjects, namely the powerful vested landholders, the barons, who sought to share that power. One of the compromises which arose out of that struggle was that in exchange for the grant of certain rights, the barons would save the king harmless for the actions of his government, thus the concept of the king can do no wrong. With the formation of the American Republic, certain vestiges of the English common law were embedded into the American system. Among them was the concept of the king can do no wrong, now translated as the states can do no wrong. Or put more simply, the citizenry could not reach the state treasury for injury received as a result of state action. This is a concept which has never really been understood, and its graft onto the rootstock of American judicial thinking has never been successful. In the common parlance, the concept is known as sovereign immunity. It's a nice-sounding term, full of all legal nicety and as mystical to the user as the Kabbalah of medieval legerdemain. But it is no longer necessary to discuss liability in terms of sovereign immunity. The courts have now gotten around to the idea that there is no place in a democracy for such a principle, and they are hastily, if somewhat tardily, dismantling the entire concept. The second concept is that of manufacture. In the process of manufacturing, there is a manufacturer and a product. If you think in the following terms, that we as government are really the manufacturer and that the highway is really the product, then all of the confusion surrounding the archaic concept of sovereign immunity should evaporate. Just as for product manufacturers, the situation for government becomes duty, negligence, injury will result in liability. How did all this come about? Well, you have all heard terms bandied about such as socialism, creeping socialism, the welfare state, and a number of others. While these terms are incendiary, there is some factual basis underlying them. The American people have always sought the better life. The New Order is concerned that all men collectively share in the burden of loss suffered as a result of catastrophe, societal developments, or personal circumstances. The widespread use of private insurance and governmental insurance, such as unemployment compensation, pension funds, and welfare payments, has accompanied the birth of a new order. This tendency has led to the development of the deep pocket theory of justice, which essentially states that he who has the greatest ability to pay for injury should do so. The individual members of society are to be protected from financial ruin through shared resources if necessary. Liability suits are in one sense no more than pension funds, unemployment benefits, or insurance policies, differentiated of course by the magnitude of recovery. Forbes details the demise of sovereign immunity and the rise of the citizen as litigator. Says Forbes, "Sue the bastard has become something of a national mindset, hitting governments as well as companies and individuals. In California, for example, generally speaking, liability claims nearly doubled between 1973 and 1975, averaging nearly 132 claims per city, with settlement costs nearly tripling to an average of $87,421 per city. As Forbes says, no one likes such anachronisms as kings can do no wrong. On the other hand, no one likes to pay the cost of putting kings on an equal footing with the masses. What then should we be discussing today? General duties are the most important guidelines in protecting against liability suits. Basically, there is a duty to maintain the roadway in a reasonably safe condition. This would involve, in essence, inspection, anticipation of defects, and conformity with generally accepted standards and practices. There is no requirement for perfect condition of repair or for actions beyond the limits of human ingenuity. It should be remembered that these cases are jury cases, and as such there is no legal foot rule by which to measure conditions generally and determine with exact precision whether a condition constitutes a defect. Each case is handled separately and included or excluded from coverage on its particular fact situation. The key term for our purposes is reasonability. There are many factors upon which a determination of what is reasonable may be based, among them the character of the roadway in question, the width and construction of the road, the slope or descent of the banks when the road is elevated, the direction of the road, whether or not the condition is obvious or hidden, points of ingress and egress, especially where there is a grade change, and traffic conditions. One situation which has caused considerable confusion recently arises in connection with the Uniform Manual, the MUTCD. It should be noted that the adoption of the manual, which allows discretion in erecting signs, does not relieve the authorities of the duty to keep the road reasonably safe for travel. In other words, where peculiar conditions alter the circumstances, something more than the manual recommendations may be necessary to guard against liability. When discussing discretion, keep in mind that the road building authority is not an insurer against accidents, that the courts have often felt that it would be too harsh an application of law to impute liability where the authorities have carried out a reasonable plan of improvement, especially in the absence of a latent as well as a patent defect, and that the adoption of a plan for public improvement is a legitimate function involving judgment. The courts have accepted these principles based upon a respect for the technician's judgment, the feeling that juries are beyond their competence when discussing planning or design because of lack of requisite knowledge of abstract engineering and legislative principles, and upon the understanding that notwithstanding technical mastery, either of the planners or the jury, it is simply beyond human ingenuity to devise a foolproof plan. Finally, it should be remembered that lawsuits arising out of accidents as a result of alleged defects in highway generally have four principal issues. First, did in fact a potentially dangerous defect exist? Second, was the defect the proximate cause of the accident? Third, did the defendant have actual or constructive knowledge of the hazardous condition? And fourth, was there any contributory negligence on the part of the plaintiff? The general duties stated above are discussed in the framework of these four issues in order that a determination of negligence can be made. I would now like to discuss two recent cases which I believe hold tremendous significance for the future of liability in the building of highways. Both of these cases are state Supreme Court cases. In the first, which was a Montana case, the action arose out of a highway accident in which 4 people were killed. The state claimed the defense of sovereign immunity and non-responsibility due to the lack of funds to construct and maintain safety features at the site of the accident. The court held that in enacting the Montana Comprehensive State Insurance Plan and Tort Claims Act in 1973, the legislature waived the state's sovereign immunity in death claims. The defense of financial feasibility or discretion was likewise not accepted by the court. As it is not a statutory defense or a constitutional defense in Montana, and since the court said that it did not exist at common law, it was not accepted. The defense rests on the premise that because the legislature fails to appropriate sufficient funds to deal adequately with all the hazards in the state highway system, the Department of Highways must exercise its discretion in allocating funds to deal with these hazards. The state accordingly contends that it should not be held accountable unless it can be shown that it was negligent in doing so. The court answered by stating that whenever and wherever it chooses to build highways, the state assumes the duty of building and maintaining them safely. The negligence of the state must, of course, still be proven. The court also discussed briefly the procedural complexities of such a defense. In every highway injury or death case, there would need be a jury review and decision on the state's entire highway program, including an infinitude of legislative as well as administrative decisions. the evidentiary burden would become unmanageable. The other recent case is a case which took place in the state of Washington and resulted in municipal liability of over $374,000 for damage to 2 jet engines which occurred when the tops of one of them struck the underside of an underpass during transport and knocked the other engine to the roadway. It is an interesting case because the undisputed facts show that a warning sign correctly stating the height of the underpass was in place and observed by the driver of the vehicle in sufficient time to stop. He did not do so because he incorrectly guessed the height of his load. The plaintiff contended that the clearance of the underpass was so low as to constitute an inherently dangerous condition, and that past experience, numerous accidents, had shown that warning signs were not adequate to prevent accidents, and that the city should have either rerouted truck traffic or invented and installed some device which would call a driver's attention to the fact that his load was too high to clear the opening. Any of these alternatives would have prevented the accident. In the absence of rerouting or adequate warning, plaintiff contended that there was a duty to restructure the underpass. The court instructed the jury that it is the duty of a municipality to exercise ordinary care in the repair and maintenance of its highways, keeping them in condition that they are reasonably fit and safe for ordinary travel. The interesting argument centered around the claim that defendant should have invented and installed an adequate positive warning. Such devices were not in common use at the time of the accident and were not commercially available. The city contends in light of this that to require such a system would be to impose the duty of extraordinary care upon the city. The court acknowledged that as a general rule, in such cases, negligence is not established, but said that there are extraordinary situations which may call for extraordinary measures in the exercise of reasonable care. In this case, the past history of frequent accidents, in spite of the warning signs, indicated the need for a more effective system. The city was found to be negligent in not doing more. Where are we heading? I would like to refer to another magazine article to conclude my remarks. The June 1976 issue of Trial, the national legal magazine of news and opinion, which is published by the Association of Trial Lawyers of America, contained an article written by Lynn Smith, at that time the director of the Highway Safety Project of the Center for Auto Safety. The article was entitled, "Highway Roadsides, Unsafe at Any Speed." Ms. Smith states that because highway officials have been slow to accept responsibility for designing safe roadsides, about 18 to 20,000 people die each year in single-vehicle ran-off-the-road accidents. An estimated 30,000 more suffer permanently disabling injuries. The indictment itself is severe, but the following recommendation should really interest you, and I quote from the article. Many highway safety experts and product liability attorneys believe that these innocent victims of defective roadside design deserve just compensation for their needless suffering. And a growing number of authorities contend that the most effective way to persuade state and federal highway officials to systematically clean up the enormous number of hazards littering existing roadsides and to reform design and construction procedures so that new highways will not repeat the old errors is through the pressure of product liability type litigation. Ms. Smith goes on to discuss the development of backup services for attorneys involved in such cases. Importantly, she considers it ironical that state and federal highway officials are convinced of the power of liability suits to force correction of roadside accident sites, and interestingly enough, considers discussions such as this inadvertent revelations of the fact. The article concludes as follows, and again I quote, "We have the right to demand that our roads, like our vehicles, neither cause us to be in an accident nor inflict unnecessary suffering on us when we are forced into an emergency. If that message has not come through to highway officials in all the congressional hearings and federal laws and highway trust fund safety programs, perhaps it can be better heard through liability litigation. One of the things that I learned in law school was an ad lib of an Aesop's fable, the theory of the camel's nose. Simply stated, it means that once the camel has his nose under the tent, less savory parts of his anatomy will follow. We are now looking at the camel's nose in the area of liability. Good luck.